Here is a question straight from the 2025 Trademarks Agent exam. What is a homonymous geographical indication? Is it A, a GI unique to one region? B, GIs that share the same name but designate different geographical regions? C, a GI not recognized legally? Or D, a GI applicable only to agricultural goods? The answer is B, same name, different regions. Welcome back to Patentworld-ai. This is Lecture G2 of our GI series for the 2027 exam. Today, we tackle two major areas. First, Section 9, which lists the 7 absolute grounds on which a geographical indication must be refused. Second, we look at Section 10, outlining the strict conditions under which a homonymous GI can actually be registered. Passing this portion of the exam requires understanding the exact contrast between these two provisions. Section 9 is an automatic permanent rejection, while Section 10 allows conditional acceptance. Section 9 states that a geographical indication falling into any of 7 categories shall not be registered. These are absolute grounds. Unlike the Trademarks Act, there is no proviso for acquired distinctiveness. No amount of use can rescue a GI hit by Section 9. Let us walk through the 7 clauses shown here. Clause A covers any GI whose use would be likely to deceive or cause confusion. Clause B bars a GI whose use would be contrary to any law for the time being in force. Clause C prohibits any GI which comprises or contains scandalous or obscene matter. Clause D targets any matter likely to hurt the religious susceptibilities of any class or section of the citizens of India. Clause E is the catch-all equity ground. It blocks a GI which would otherwise be disentitled to protection in a court. Clause F bars generic names or indications. We will do a full deep dive into this specific clause in a moment. Clause G is the trickiest. It refuses a GI which, although literally true as to the territory where the goods originate, falsely represents to persons that the goods originate in another territory. If a town in one country shares its name with a famous region elsewhere, the label might be technically true, but the message it sends is false. To recall all 7 absolute grounds in order for the exam, use this memory device. DLSRCGT, deceive, law, scandalous, religious, court disentitled, generic, true but false. Notice the statutory structure here. The GI Act packs all these prohibitions into a single section, whereas the Trademarks Act splits its absolute and relative grounds. Triggering any single letter in that DLSRCGT acronym means the GI application is permanently dead. Reference the text on screen. Clause F is the only ground with statutory explanations, and examiners quote them word for word. Explanation 1 defines a generic name as one which, although it relates to the place where the goods were originally produced, has lost its original meaning and has become the common name of such goods. Take cheddar for cheese. This name began as a real physical place in England, seen here, but eventually became a designation of the product's type. The same applies to Dijon for mustard, originating from the historic streets of Dijon, France. Consumers no longer link the product exclusively to the geography. Reference the text on screen. Explanation 2 gives us the test. In determining whether a name has become generic, account shall be taken of all factors. The first mandatory factor is assessing the existing situation in the specific region or place where the name originates. The second factor is assessing the area of consumption of the goods. Pay close attention to the strict double condition built right into Clause F itself.
For a GI to be refused as generic, the name must be generic, and it must have ceased to be protected, or fallen into disuse, in its actual country of origin. If a test question states that a name is still legally protected as a GI in its home country, India cannot refuse it under the genericness clause. Let us move to Section 10. Homonymous GIs are 2 genuine geographical indications that share the exact same name but point to completely different geographical territories. There is a textbook global example for this. First, we have the famous wine region of Rioja in Spain. Second, we have another wine region called La Rioja in Argentina. Both claims to the name are entirely truthful. Section 10 says a homonymous GI may be registered at the registrar's discretion, provided it passes a 3-part test. Step 1. Evaluate the practical conditions differentiating it from the existing one, usually specific labeling. Step 2. There must be equitable treatment of the producers in both regions. Step 3. The registrar must be satisfied that consumers will absolutely not be confused or misled. Procedurally, Rule 32 requires the applicant to explicitly state those differentiating factors and protective measures right inside their application. Keep this clear for the exam. A homonymous GI features two honest parties, where geography simply repeated a name. This is entirely different from deceptively similar marks, which involve one honest party and one copier. Draw attention to the comparison table. You must draw a sharp boundary between how the GI Act and Trademarks Act handle refusals. Trademark law uses Section 9 for absolute grounds and Section 11 for relative grounds, while the GI Act packs all prohibitions into Section 9. The critical difference involves acquired distinctiveness. Trademarks Act Section 9 allows descriptive marks to be saved if they acquire distinctiveness through use.
The GI Act has no such proviso. A generic name is dead forever, no matter how much it is used. Conversely, as tested in 2025, a trademark containing a geographical name can be registered under trademark law if it has acquired distinctive character. Mentally separate these two regimes. Principles of commercial use that save a trademark will instantly kill a GI if it violates Section 9. Watch for modal verbs in your multiple choice options. Section 9 uses the mandatory shall not for refusals, while Section 10 uses the discretionary may for homonymous registration. Let us finish with a rapid-fire recap. Question 1. How many prohibition grounds exist in Section 9? 7, clauses A through G. Question 2. Can acquired distinctiveness cure a Section 9 objection? No, there is no proviso. Question 3. Which two factors govern the generic name test? The situation in the region of origin and the area of consumption. Question 4. What is the famous homonymous GI example? Rioja, Spain, and La Rioja, Argentina. Question 5. What is the three-part test for homonymous GIs? Practical differentiation, equitable treatment of producers, and no consumer confusion. Question 6. What section refuses a GI that is literally true, but falsely suggests another territory? Section 9, Clause G. Question 7. Where must differentiating factors be disclosed? In the application under Rule 32. That completes Section 9 and 10. In our next video, Lecture G3, we cover the entire registration procedure, including the consultative group, opposition timelines, and the 10 rupee authorized user application. Subscribe, download the notes, and I will see you in the next class.